Hello, everyone. My name is Rita Anwarichinda, and this is hashtag IP series. So, for my new listeners just joining in, thank you guys so much for making out the time to listen to my podcast. Please don't forget to favorite and subscribe. You can listen to my podcast on Spotify, Anchor, Breaker, Radio Public. Here I talk on recent intellectual property cases and development globally. This could take the form of copyright, trademark, patent, industrial design, trade secrets, plant varieties, and geographical indication. And for my returning listeners, thank you guys so much for always coming back. Today's episode is a very interesting one. So we're thinking designs, we're thinking UgoMonye, we're thinking coming to America. So stay tuned guys as we get into the deets of today. So Coming to America premiered on Amazon Prime a few days ago, and a lot of controversy followed it. So you're talking, we have the Nigerian fashion designer at UgoMonye.official who said, our patent 2017 Reale design, aka Ebuka Agbada, replicated and featured in Coming to America. I mean, you all should remember, you all know the famous Ebuka Agbada that Ebuka's fashion always breaks the internet, but that one, I don't know the right word to use now, but he was viral. And so I got a tag. A colleague tagged me. I was like, okay, yo, come and clarify this. He even came to my inbox. I was like, can the design be patented? And I was like, okay, I think I should really do something. And I got a few persons reach out to me and like, okay, I'm actually going to do that. And I had to take my time to do a research on this. And I did the tweet. So here's the podcast version. So, can a design be patented? Let's find out in this episode. First of all, patent as an intellectual property grants the inventor government authority to commercialize and license the exclusive right for a term of 20 years, thereby preventing other people from using, making, or selling within that particular territory the patent was registered. Remember, IP is territorial in nature. When you're dealing with IP, consent, permission, authorization is key and very important. It's also very mandatory for the people who don't own the intellectual property. You need to obtain a CPA so that you can do the acts that are exclusive to an IP owner, like make or sell or license. And the requirement for patenting an invention is that 1. It must be new or novel. 2. Must have an inventive step that is not obvious to a skilled person or someone with the knowledge and expertise in that particular area. 3. It must be capable of industrial application. And finally, it must not be contrary to public policy and morality. What we need to know that when it comes to a patent, if your invention improves on an already existing patent, it can be considered to be new, depending on the functionality of that invention in question. You can check out section 1 sub 1 paragraph A to B and subsection 2 paragraph A to C. Now I did a poll and I asked, do you think the Reale design, aka Ebuka design, is a new invention? 42.9 said no, 28.6 said yes, 14.3 said they are indifferent, and our famous phrase at the moment, Lori Law. I hope I pronounced it well, but yeah. I also do not think that the design is a new invention, because Agbada is not peculiar to a particular tribe. So it's more like an African cultural dress. Now, the right of a patent belongs to the person who is the first to file or even lay a claim to a foreign priority. For instance, if like you already have like an international registration, you can lay a claim by saying you were the first person to file it, especially when you want to come and file in Nigeria, whether or not you are the true inventor. I mean, it's really heartbreaking, don't you guys think? So, see Section 2, Sub 1 of the Patent and Design Act. One thing you should know is that if that this invention was made, say you signed a contract, you were commissioned, then you signed a contract, or it was made while you were employed, it's going to belong to the employer or the person that commissioned the work. Read or see Section 2 sub 4. However, subsection 4 paragraph A provides that in the case where an employee in his contract, it provides that he doesn't need to explore his inventive side, but he can still make use of the materials from his workplace. Then he's entitled to a fair remuneration, which is not modified by the contract and may be enforced by civil proceedings in court. I mean, that totally makes sense. Like, I can use your materials but still earn from it, and also you still earn from it. Subsection 5 further provides that even if you merely assisted in doing the work without the development of an invention, without actually even contributing any inventive activity, then you cannot say you are the inventor. So if you did not contribute, you did not even add shishi, you can't come out tomorrow to say, oh, I'm the inventor of this. Hope you that's clear. The rights that a patent owner owns according to Section 6 sub 1 includes: 1, you have the right to stop other people from doing the following things. Where a patent has been granted in respect of a product, the act of making, importing, selling, or using the product or stocking it for the purpose of sale or use. You can also prevent others where the patent has been granted in respect of a process or the act of applying the process of doing, in respect of a product obtained directly by means of the process, any other acts mentioned in paragraph 8. These are just legal legal jargons, but basically what it's saying is that you can prevent other people from that. Even when you have given them a patent, so I've licensed it to you, you can now restrict them from doing certain acts that are also exclusive to you. So if I'm selling to you, I'm selling to just you, you cannot sell to another person. That's like the long and short of it. Then subsection 2 provides that where the protection of a patent, then the protection of a patent shall be determined by the terms of the claim and the description, and that is the plan. So it's like when you're applying for a patent, you're going to do like a drawing called a claim. So your where the protection of your patent, where there's a protection of your patent, this will be determined by what you claimed while you were applying. So those little drawings, they are very, very important. It's always the little things that is considered. That's what will be used to interpret your claims, because in that drawing you're going to specify the functionality, what makes your product unique and new, and that it deserves to be patented. Subsection 2 further provides that patent rights shall extend only to acts done for industrial or commercial purpose, and shall not extend to acts done in respect of a product covered by the patent after the product has been lawfully sold in Nigeria, except where the patent makes provision for a special application of that product. In this case, it shall continue to be reserved to the patentee, that is the person that licensed the invention. So what cannot be patented? Remember, IP is territorial, and according to Section 1 sub 4, a plant or animal variety cannot be patented. Biological processes for the production of plants or animals cannot be patented as well. Inventions of publication or exploitation that are considered to be contrary to public order and morality cannot be patented as well. Principles and discoveries of a scientific nature are not invention. So, here's a summary of the case study for today. Now, when Coming to America was premiered on Amazon Prime, UgoMonye took to his Instagram account stating that their patented Reale design was used and featured in the movie, and he put a side-by-side picture to showcase it. Now, to answer this question, can a fashion design be patented? And in order to, get to this answer, you need to understand the basic things. First, you need to identify if the design as an invention meets the requirement of being new or novel, capable of industrial application, and not obvious to a skilled person with knowledge. That means if I give it to someone within in the same line of business with you, can the person be able to reproduce what you just did? That is someone that is skilled with knowledge and expertise. Now, it's best that a fashion designer opts for a design right, because a design right will protect the combination of lines, color, the aesthetic features of the design, while copyright will protect the sketches and trademark, the name, sign, symbol affiliated with that design or collection in question. And in this case, we're talking about the Reale design. So Reale in this case is spelled as Reale, or let me just call it Ebuka Agbada design. You know that, let's call it burger, no burger, mauve, the mauve colored Agbada that broke the internet. Now, as a fashion designer, patenting your design is a bit technical, to be honest, and you would have to state in your claim that when you're doing a patent application, what's the functionality of that design. Basically, what that means is that what makes your design or your invention unique and different from every other invention out there. What is your invention curing? What is it improving on? And our patent law did not list the fabric as an eligible work to be patented. So I'm going to give an example of a clothing design that has been said to be patented. Now, the famous Zendaya 2019 Met Gala Cinderella dress took 8 months to create, a team of 8, 20 carbon fiber rods, 5 battery packs, and 40 meters worth of LED lights. Now, the idea between why I'm using this as an example is to show you the efforts that was put into making this Cinderella dress. We all know Cinderella dress is like a ball gown, but you had to, be creative in your invention, and that's what they did with the Zendaya Met Gala dress. Like, the designer was like the fairy who turned Zendaya's dress at the red carpet into a Cinderella dress. Now, if you take a look at the UgoMonye Agbada, aka Ebuka Agbada, what do you think, what aspect of the dress can be patented? So on Twitter, I had asked people to point out the functionality of UgoMonye's Reale design, aka Ebuka design, and I got, not on Twitter, but my personal email number. Someone had pointed out that the design wasn't new, as the design itself is like a regular dress, or is being made in the northern part of Nigeria, and it was interesting to hear about that. Now, what do you do when your creative work is used in a motion picture or a film or video without your consent? First of all, talk to your IP lawyer. Talk to your IP lawyer to determine if the use can be qualified as an infringement. Brief your IP lawyer to do a demand letter, aka cease and desist letter. Make efforts to actually resolve that dispute. That is, if a dispute really do exist, say no to social media call out. Although that's worked for a few persons, like Louis Agilo and the Living in Bondage movie saga that happened during the pandemic. You can listen to my podcast. I talked about it then. I also did a tweet about it. Then, always, 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 always opt to settle your matter either through litigation or by going to court, or explore alternative dispute resolution mechanism like mediation, arbitration, conciliation, expert determination, hybrid ADR mechanism, or even ODR. And also, as an IP lawyer, um, always confirm if your client's work is an eligible work under the relevant form of IPs. Make sure that it meets the requirements before you even proceed to registering the mark in question. So, what are the intellectual property rights a fashion designer can opt for or explore? First is design right. Now, Section 12 of the Patent and Design Act provides that a design can only be a combination of lines or colors, or even line and color, and any three-dimensional form, whether or not it's associated with colors, if it is also intended by the inventor to be used as a model or pattern to be multiplied by industrial process, and is not intended solely to obtain a technical result. Now, while Section 13 lists what can be registered, or what qualifies to be registered, so you must confirm that the design is indeed new and is not contrary to public order or morality. And in the tweet I put the famous Ebuka Agbada and some other, the one that UgoMonye actually did, and then a replica that someone did a few weeks after the Ebuka Agbada was released. And then I asked, there any similarity? I don't see any visual appearance or similarities of the clothes, that's the Agbadas, both the one used in Coming to America and the UgoMonye's design. Now, subsection 2 provides that where an application is made for the registration of an industrial design, the design in question shall be presumed to be new at the time of application, except where the provision of the section provides otherwise. Subsection 3 also provides that a design is not new if before the date of application, that's even before you apply, you have already made your design, you have published it, made it available to the public, like you've put it out there, and at any time, by any means of description, use, or in any other way, unless that you have shown the registrar to the satisfaction of the registrar that the design could not have, that is, the designer could not have known that it had not been made available. Subsection 4 provides that an industrial design shall not be deemed to have made available to the public solely by reason of the fact that within the period of 6 months before the person filed his application, the creator of the invention had exhibited it in an official or officially recognized exhibition. So I now did a poll and I said, did UgoMonye exhibit the Ebuka Agbada anywhere? 66.7 said yes, Ebuka na evidence, and I agree, he did exhibit it. Then 3.3 said no, right? 0% said maybe, so nobody voted. Subsection 5 provides that a design is not new merely because it differs in minor or inessential ways from an earlier design or content. A type of product other than the type with which an earlier design is concerned. So basically, if you're saying, oh, this Agbada is new, subsection 5 is saying that your design will not be considered to be new simply because it has like very minor or maybe inconsequential changes to the earlier design. So your own design is not new. Now, who has the right to register a design? Who has the right to register a design? Section 14 sub 1 states that the statutory creator or the person who may or may not be the true creator is the first person to file or claim a foreign priority. And then under subsection 4 provides that ownership shall rest with the employer or the person who commissioned the work. Now, how do you know when a design has been registered and published? Section 17, sub 1 provides that um, through the certificate that will be issued by the trademark registry, and also a notification will be sent um, in the summary form of notification that the rights of the designer gets that the rights of the designer has been registered, so he can get the certificate. Now, rights of a design owner is that he gets to enjoy exclusive rights to reproduce the design in the manufacture of a product, import it, sell it, utilize it for commercial purpose, hold such a product for the purpose of selling it or utilizing it for commercial purposes. Time of duration and renewal can be found in section 20, which provides that it shall be effective for the first instance as for the first 5 years from the date of application, and subject to renewal for 2 further consecutive periods of 5 years. But with an IP strategy, you can keep renewing and making money. On commercialization and exploitation of a design, section 23 sub 1 talks about a contractual license, that is having a written contract which has to be registered. And also in subsection 2 it stated that it shall have no effect on any third party until it has been perfected and shall be cancelled at the request of the licensor. And if the registrar is satisfied that the contract, that's the contractual license, has indeed been terminated. Subsection 4 provides that where there is no contract for a license, it shall not prevent the licensor, that is the owner, from granting licenses to others or even exploiting it. Design rights are not assignable, and the licenses shall not grant a license to others. Now, this section applies if Coming to America had wanted to use a real design, basically. So whether or not they sign the contract, it does not prevent UgoMonye in this case from licensing it to other people. That's what that section means. Now, what would the courts look out for in the event of a dispute? 1, the visual similarities of the design, that is the aesthetic features. If it can be assessed, that's the infringing material. If it was easy to assess, for instance, now when the Ebuka's design went viral, everyone basically saw it, which makes it possible for someone outside Nigeria to also imitate or copy. The designer may have seen it cross his timeline. There's also a thin line between inspiration and copying. You just need to know where to draw the line, especially if it's a parody. Now, a parody is defined as an imitation of a style or particular writer, artist, genre with deliberate exaggeration. That means you're exaggerating the comic effect. Now, it is also a defense under the fair dealing principle, whereby you can use a copyrighted work without the express permission, without obtaining permission, consent, and authorization from the owner of the IP work. If you're using it for research purpose, private use, or reporting an event. Now I ask, can the real design be considered to be a parody? 100% said no, and I agree. Now, is the design in Coming to America creative and different from UgoMonye's real design? 50% said both are the same. 50% said Coming to America copied UgoMonye. I don't think UgoMonye was copied, more of like an inspiration, which is why I said you need to know when to draw the line when you are dealing with infringement disputes. And I did another poll. Do you see any potential infringement? 55.6 said no, while 44.4 said yes. I also do not see any potential infringement. Now, when your design has been registered, you can put out a notice, just like how Diola Sajo did in 2019, where after she registered the Komolu material, she said intellectual property notice violation will not be tolerated. So I think fashion designers need to start thinking bigger when it comes to their design. Start exploring IP, be intentional about your creations, etc. etc. So moving on, another form of IP protection a fashion designer can opt for is trademark. So trademark basically protects the name of your collection, the sign symbol that can be linked to the design, and also relevant to the class which the mark is going to be registered. It also must be distinctive in nature, that is, it must be unique and not likely to cause confusion amongst your consumers. Straight to the point, example: D&G, Prada, Louis Vuitton, um, Louis Vuitton. You know them, all the big brands and luxury brands are there. Another form of IP you can consider is copyright. Copyright protection for the artistic work or sketches in a fixed medium, say for instance a book. Now section 51 lists painting, drawings, etchings, lithographs, prints, engravings as being copyrightable, while paragraph F lists works of artistic craftsmanship as well, and also pictorial woven tissues and articles of applied handicraft and industrial act. However, section 1 sub 3 provides that for an artistic work, it will not be considered to be eligible for copyright protection whereby when the work was created or made, the author did not intend to use it as a model or pattern to be multiplied by industrial process. Now, if you're a big Marvel fan, you remember that when Black Panther was premiered in 2019, the Ghana National Folklore Board wanted to sue Marvel Studios because they had used kente in some of the costumes, which they said required permission, and Marvel Studio had used kente without their express permission. And under their law, you can't use kente for commercial purpose unless you obtain permission. Now, what's the difference between these two cases? Now, kente is said to be protected by the Copyright Act of Ghana as a folklore, with distinctive designs and colors associated with wealth and celebration, made in form of strip weaving produced by two ethnic groups in Ghana, namely Asante and Ewe. Now, folklore under the Nigerian Copyright Act is defined as production of folk arts, in particular drawings, paintings, carvings, sculptures, pottery, terracotta, mosaic, woodwork, metalwork, handicraft, costume, indigenous textile. Now, from this definition, do you think folklore protection will apply to the real design, aka Ebuka design? And 100% voted no. I also do not think that the Ebuka design qualifies to be registered or enjoy protection as a folklore. Now, another case is Frozen 2. Now, let it go. Let it go. Few seconds, please. Now, when Frozen 2 premiered in that same 2019, that was during the Christmas period, Princess Anna's boot was linked to Christian Louboutin red sole shoe, which was considered to be similar. This was identified by an IP US attorney. And we know that Christian Louboutin has been fighting off people who had tried to take advantage of his color red mark, because the truth is, when you see a red sole shoe, the first thing that comes to your mind is, oh, that's a CL shoe, that's a Christian Louboutin shoe, that's a Louboutin, And I think it was, the main thing when it comes to trademark dispute is if there's a similarity or if your consumers can confuse A for B, then there's a likelihood of confusion. However, Christian Louboutin did not say a word. No one said anything. Especially with regards to how he has been aggressive in suing other fashion brands like YSL, So, in conclusion, UgoMonye has a lot to do in terms of truly proving that the functionality of his design as a patent, since he's alleging that the real design, that is aka Ebuka design, is similar to the one used in Coming to America. As a fashion designer, you need to have an IP lawyer on your retainer so as to be properly guided. I mean, from the moment you start sketching to when you go into production to when you're about to showcase your line, you need an IP lawyer to guide you. Oh, I think this is similar. Then you also go as far as trademarking or doing some form of IP registration. Also opt for a multi-layered IP protection. So you're thinking copyright, trademark, design rights, Also have like an IP strategy for commercializing and exploiting your design. Register your IP as it gives you exclusive right to do what they ask according to an IP owner. Know that consent, permission, and authorization is very important and key. Also know that IP interfaces with every sector. And to wrap it up, I do not see any visual appearance that may be similar between the agbadas used in Coming to America. Okay, I'm a bad singer. Yeah, I do not see any visual appearance between the two agbadas. I mean, let's be honest. But then I think everyone is entitled to their opinion. This is my own opinion, honest opinion, as an IP lawyer. So let me know what you guys think. Do you see any visual appearance, or are you just being sentimental because you're being patriotic and you're supporting your Nigerian person? But let's talk. And we have come to the end of today's episode on whether or not a design can be patented. Let me know what you guys think and see you at the next #IP series.